Hello, my friends. Svetlana Shlapak from UKVisaSuccess.com is here, where the UK immigration system is explained in simple terms. This is part 6 of my Permanent Right to Reside series, where I explain various routes for EU nationals and their family members to settle in the UK. Category number 6 is a very unusual category because it includes many people who were not even aware that they could qualify for permanent residence to reside. So I strongly recommend that you pay close attention to this particular category. And as with all my videos, I've done my best to split it into very easy to understand and digest parts. So I'm sure that if you bear with me until the end, you will be able to understand this particular category. If you're not part of this video series, you're more than welcome to subscribe by clicking the link below. If you do, you will get plenty of information, very useful one and sometimes very surprising one, because there are lots of people who are not aware of their rights. And this is partially why I'm here. This is why I've created my website, and this is why I am creating these videos for you to explain various routes which will give you various rights to reside in the UK. So let us begin with category number 6. It's all about family members of EU nationals who, for certain reasons, retained their right of residence in the UK. So let us begin with category number 6.
A person who has resided in the UK in accordance with regulations for a continuous period of 5 years and was at the end of that period a family member who has retained the right of residence will acquire a permanent right to reside in the UK. Let me jump straight into explaining who can claim that they have retained their right of residence in the UK, despite the fact that they are no longer with an EU national who gave them the right to be in the UK in the first place. There are 4 possible case scenarios here. Scenario number 1, when an EU national died. Scenario number 2, when an EU national has left the UK or died, and his or her child, grandchild, or great-grandchild has remained living in the UK. And I mean here non-EU national descendant, child, grandchild, or great-grandchild. Case scenario number 3, when a non-EU national person is a parent of a child who retains the right of residence in the UK. And finally, number 4, when an EU national divorced with their non-EU national spouse, or he or she became a victim of domestic violence. In the first case scenario, you have to have to prove 3 points. The first point is you were a family member of an EU national who was a qualified person or had the right of permanent residence in the UK when he died or she died. I've provided you with a very detailed guidance on who can be considered to be a family member of an EU national in my previous video series, so there is no point for me in giving the same details here. But in summary, I would like to say that family members can be direct and extended. Direct family members are spouses, children, grandchildren, great-grandchildren under the age of 21, or financially dependent, or another category of family members are dependent parents, grandparents, and great-grandparents. And extended family members are relatives who were either residing with an EU national in another country or were financially dependent on them in that country, and they will continue with the same arrangement in the UK. In other words, they will continue to either be financially dependent or to be living in the same house. Also, relatives with health issues and those who need some care will be, one of the categories which relates to extended family members, and also partners in durable relationship. Okay, the second point in our first case scenario is about people who can retain the right of residence in the UK. Is that when an EU national died, he was living in the UK in line with the regulations, which means he was either working, studying, or he was self-sufficient. And he has lived in the UK for at least 1 year before his or her death. And point number three in this particular case scenario is that the family member who remained living in the UK after the death of EU national is now a worker, self-sufficient person, or self-employed. In other words, that they can prove their financial credibility, because they don't want anyone to be a burden on the society here in the UK, which is understandable. Case scenario number two is about a direct descendants of an EU national. Direct descendant means a child, grandchild, great-grandchild. Anyone who wants to benefit from this particular regulation will need to prove that, number one, their EU national family member has either left the UK or died. Number two, that he is a direct descendant of either an EU national person or his or her spouse. And number three, that he or she was studying at the time when this happened, was an EU national person, in other words, when he either died or when he left the UK. And at this present moment, the person who wants to claim the retained right of residence continues his education. Case scenario number three is a very simple one. It is for a parent of a child from the case scenario number two, the one which I've just described. So all we have to prove here is that the child is under the age of 21, and that the parent who is claiming to have retained right of residence in the UK has the actual custody of the child. The last case scenario number four is for divorcees and victims of domestic violence. This is a complex area, but bear with me. I promise that you will be absolutely clear by the end of this video, because I will explain this very clearly, and it will be very easy for you to understand what this category is all about. Right. To meet this condition in this case scenario, we have to prove three things. Number one, that you cease to be a family member of an EU national on the termination of marriage or civil partnership. And we are talking here about a termination. We are not talking here about separation. We are talking about the case scenarios where you actually divorced. So a mere separation will not be sufficient. Number two, when your marriage was terminated, you still resided in the UK. Just received an inquiry from a guy who is from South Africa, and it was very unfortunate. He could have benefited from these provisions, but the only criteria which he hasn't satisfied was this one, and that he has resided in the UK at the time when the marriage was terminated. He's left already the country. And this is a crucial difference, guys, here. So if you make an application hoping, and by the way, his application, he submitted the application several times, and it was refused, and he was not sure why it was refused. It was refused simply because this condition number two, was not satisfied. So before making the application, you have to make sure that you completely understand all requirements for your eligibility to make permanent right of residence. And this video does exactly that. It explains all the areas. Okay. The third point we need to prove is that when you make the retained right of residence application on the basis of your divorce with an EU national spouse, you have to be a worker, self-employed or self-sufficient. Once again, you have to be financially credible in order to make the majority of the applications under the EU law or immigration law in general. In addition to that, you can prove, you should actually prove the following: that your marriage lasted for at least 3 years, and that you have resided in the UK for at least 1 year when your marriage was still subsisting. If you think you don't satisfy this particular requirement, you can still claim your retained right of residence on the marriage or on the basis of your divorce with the Indian national husband or wife, if you can prove that you have a custody of your child with an EU national, and you have the or you have the right or access to that child. So it's either a custody of the child, which is quite common when you're a mother, and you have the right of access of a child, which is quite common when you're a father. And that child has to be under the age of 18, and the court has ordered that the right of access to a child must take place in the UK, which is quite common as well when the child is here and he's studying or she's studying, so it should not be a problem. Again, if you don't satisfy any of the above, you can still claim retained right of residency if you can prove that you were a victim of domestic violence. So if you can prove that you were a victim of domestic violence, you should there is no necessity for you to prove that you were residing with the person for 3 years. So all you have to prove, you have to get a strong documentary evidence confirming that you were a victim of domestic violence. This is a very, very, very challenging application because the burden of proof is on you, first of all, and secondly, you will need to gather a lot of documents to prove that you meet these particular requirements. And if you think you would qualify under any of the provisions which I've just mentioned, and you are not subscribed to my email list, please do so at bit.ly/PR rules, and in one of my emails I'll explain to you how you can take your application to the next level. So I'll explain where you can get further help. Right, moving on to the next part. It is very important to remember that in the case scenarios where you were required to prove that you were either a worker, self-sufficient person or self-employed, and you meet this requirement, you all of a sudden, so you meet the requirement at the time when you made the application, and then once the application is approved, you've lost your job. It is very, very important for you to understand that you will lose your right to remain in the UK almost automatically. So it is very, very advisable for you to make sure that you start saving, making savings. If you are in the position of a person who is who can claim retained right of residence in the UK, I strongly suggest that you start making savings as soon as possible, because in case you lose the job, in order for you not to lose your right to live in the UK, you have to have some savings to prove that you're a self-sufficient person. So guys, make sure that you start saving, just to have a backup plan in case you lose your job. Right, a non-EU national person can claim permanent residence to reside in the UK if he or she can provide that he has resided in the UK in accordance with regulations, and that at the end of this period he has retained a right of residence. And once again, just to summarize for you, here I would like to say that there are 4 possible case scenarios where non-EU national person can claim that he or she has retained the right of residence. Number 1, when an EU national died. Number 2, when an EU national person has died or left the UK, and there is a child who is still in the UK and who is in full-time education. And he's the direct descendant of that EU national person. Number 3 is about parents from the category number 2. He should be the child should be under the age of 21, and the parent who is claiming retained right of residence will need to show that he or she is a primary carer for the child. And number 4 is for those who divorced with an EU national or became a victim of domestic violence. And And this was the end of my last video, video number 6 of the permanent right to reside for EU nationals and their family members video series. If you haven't already subscribed to this video series, please feel free to do so at bit.ly/PR rules. After subscribing, you'll get 7 emails from me covering 6 categories of people who may qualify for permanent right to reside in the UK. And in these emails, I'll also provide you with additional information clarifying the similarly complex immigration categories, and also explaining how and where you can get further help with your permanent right to reside applications. It was my sincere pleasure helping you understand this complex aspect of EU law, and I hope that you are now crystal clear about the rules. Thank you so much for all your kind words. I'm glad that for those of you who took the time to, to say thank you. I'm so glad that you found my videos useful. That's exactly why I'm here. I'm here to deconstruct difficult aspects of EU and UK immigration law. And if you found them useful, if you found this video useful, please feel free to spread the word to those who may benefit from the videos. As always, this video was created by me, Svetlana Shlapak, at ukvisasuccess.com, where the UK immigration system is explained in simple terms. This is all from me for today. I wish you best of luck and have a great day.